Hello. I am so sorry. I'm waiting. Tay says we're having anxiety waiting. Hi, I'm so sorry. Okay. Yeah, you know what? StreamYard's really been pissing me off, and I've actually seen it as I've watched other channels too. I'm getting ready to switch, but I need to do a test live to see what's going on with the other platform. But I'm breaking up with StreamYard pretty much. Anyways, thank you for being here. Hello, hello, hello. We are going to be covering the new document that I just got my hands on it thanks to Paula. If you don't know who Paula is, she's Paula from Plunder. Love her, adore her. She got these and I was like, scoop. And she was like, go right ahead. And I was like, dope. So thank you to her. Although I do contribute, I also do like to give credit. So there was 5 of them that released. Hello, hello. Thank you for being here. I know it feels weird. I feel a little off because I don't usually go live during the day unless it's like the weekend. But I'm trying to switch things up. So I want to go live more during the day. I would have gone live earlier, but I had a couple things to get done. So let's get started. There was, I think, a total of 5 documents that were released today. I couldn't load them in share screen, so I couldn't share screen, so I just uploaded them. Um, a few were, let me pull them up. I'm gonna read the ones that were fairly short. 2 of them were just about counsel. Um, like, assistants and counsel's gonna jump in or whatever. So a few of them are really short, so I'm not gonna pull those up. I'll just tell you what they say. And then the one that's 21 pages is the one that has, I think, the most information. That one we'll read in whole. Sorry, give me a sec. So the first one, and let me say hello to everyone. Not me being rude. Okay. And are doing a Kenzie live today early. I know it's gonna be fun. Hey, Alcine, I saw Widow. I saw Bolitas and Laura in BNG. Tay, hello, hello. Joker, what is up? I was pulling my hair out waiting for you. Stop it. Hey, First Liberties. Hey, Nama Owens. Good to see everyone. Okay. So the first one is notice of limited appearance, and it basically says Attorney Stacy Visor of the firm Brown, Bradshaw, and Moffat hereby enters appearance as associate counsel for defendant Tyler Robinson. That was one of the documents. That's why I said like a few of them are just really short. I am gonna pull. Sorry, I have 2 screens going here. Let's see. Okay, this is. I'm gonna remove that one. Sorry, hold on. Let me add. Are they all the same? Okay, this one's it. So this is a 5-page one. Sorry, StreamYard sucks lately. This one is the stipulated motion for discovery protective order. And if you don't know who Tyler Robinson is the guy who unalived Charlie Kirk. I know it's controversial. I try to not cover politics on my channel. We don't do politics here. So we do stay respectful. All opinions are welcome. Please stay on topic and just respect everyone's opinion. I'm cool with people having different opinions, but I don't like when it gets aggressive. So but I do want to cover this. I have been covering Charlie Kirk. I think the one live that I do have is members only. So yeah, you have to be a member, I guess, on that one. This one is not members only. I don't know if I'll make it members only. Probably not. I do want to give a warning as well. YouTube has been on us. Like they do not like a lot of words. And I always come up here. I actually have a good relationship with them, so I feel like I do all right sometimes. But I'm going to be talking about the Ellen Greenberg case, and so they don't like specific words that I'm going to be saying in that case. If you're not familiar with the case, please, please, please join me. We are deep diving it. We're doing part 1 tonight. I have all the documents. It's a gazillion. I still have to go over Gabby Petito too. I just get an overwhelming abundance of documents that I'm like, I have like a list of what I've already read through in cases. and what I have to go. And I got all of them on Ellen Greenberg. So I'm going to do a part one today, later tonight. That might be like a little later. So we're going to deep dive. That means we go through everything. But anyways, back to Tyler Robinson. Let's get started on this document. This is a stipulated motion for discovery protective order. And it says the parties respectfully request the court issue a protective order governing the disclosure of discovery material produced to the defendant through his counsel and further restricting the disclosure of personal identifying information of witnesses. Utah Rule of Criminal Procedure allows the parties to impose reasonable limitations on further dissemination of sensitive information provided in discovery to quote unquote protect victims and witnesses. The prosecutor or defendant may impose reasonable limitations on the further dissemination of sensitive information otherwise subject to discovery to prevent improper use of the information or to protect victims and witnesses from harassment, abuse, or undue invasion of privacy, including limitations on the further dissemination of recorded interviews, photographs, or psychological or medical reports. Upon a sufficient showing, the court may at time order that discovery or inspection be denied, restricted, or deferred, that limitations on the further dissemination of discovery be modified, or make such other order as is appropriate. The discovery in this matter is voluminous and complex. While the state has taken and will continue to take every reasonable effort to redact discovery materials, the governing victims and witnesses' rights redaction of every file is not feasible due to the volume of material and the format of some material, including video and audio files. Therefore, the parties stipulate and ask that the court issue a protective order as follows. Limitation on the use of discovery materials. I know the Charlie Kirk case is very controversial, and do we believe, like, and by we I mean you guys in the chat, do you guys believe Tyler Robinson is the real person who killed Charlie Kirk? Oh no, there I go saying the bad words. Because a lot of people don't believe that. And so I know it turns into a political thing, but let me know your opinion about this Charlie Kirk debacle that's going on, and RIP Charlie Kirk. I was never like a big Charlie Kirk fan. I knew who he was, but as of recent with his passing and well, his unaliving at the hands of someone else, and that is questionable. It's been interesting to get into it a little bit. And when I was saying about the warning earlier, I was just saying words get your comments flagged. So it's not me and my mods. I reviewed a live last night because I think people's comments were getting removed, and it was, I think, YouTube. Carrie says, nope, I don't think it's him. He is the fall guy. Tay says, I do. Debbie says, no. Melanie with the bad words. Yes, Charlie. Hey, Laura. Hey, Debbie. Did I say hi to Debbie? Debbie's always wonderful. Okay, let's get started. Limitations on use of discovery materials. Information provided in discovery shall not be shared with any person or entity outside of the defense team, but may be reviewed by potential witnesses in the presence of a member of the defense team as deemed necessary by counsel. Information provided in discovery may be shared with attorneys with whom defendant's counsel of record deems necessary to consult, as well as the consulting attorney's respective office. Staff is necessary to facilitate the consultation. Consulting attorneys and their staff shall not share or disclose discovery information in any way. I just don't understand why the discovery information has to be a secret. And if you guys watch Candace Owens, I do watch Candace Owens. I actually love Candace Owens. I know that's also controversial, but she has a lot of good information on the Charlie Kirk case too. Defense team, as used in this paragraph, includes counsel of record and their office staff, defensive investigators and experts, and their respective office staff and the defendant. The paragraph is further limited by paragraph 2 below. Limitations on use of personal identifying information. Personal identifying information includes dates of birth, social securities, and email addresses which are shared through discovery. Personal identifying information does not include the names of witnesses. Defense counsel may not share personal identifying information of witnesses. Okay. Personal identifying information may be shared in view by attorneys of record investigations and their office staff as necessary to prepare for trial. Okay, we're done with that document. The other one, before we get to the 21 page. Okay, this one is I'm going to remove this document because we're done with it. Request to submit motion for permission to file over length motion to appear in civilian clothing without restraints. Defendant Tyler James Robinson by and through undersigned counsel. Wow. He wants to be in regular clothes and not restrained when he goes into court. This is wild. This is a wild case. I believe it was him, but they're not being forthcoming about the details. Basic, First Liberty says basic rule of law statements of a party opponent are always admissible. Tyler's the government's opponent and he put himself at the scene of the crime. He's screwed. He should be restrained. Really? Okay, Laura says he should be restrained. All right, let's get started on the bigger document. So, page 1. Oh, sorry. Let me pull it up on my end. The Kenzie text came up. I'm like, oh, wait. I'm going to read it on this screen in front of me. But you guys can read along on the screen. So this is, and these all are dated within this last week. This one that we're reading is 9th of October. So just a couple days ago. Okay. Defendant's motion to appear at all in-person proceedings in civilian clothing and without restraints and memorandum in support. State of Utah versus Tyler James Robinson. Restrained for trial or court appearances. Both, I guess. Hey, Valerie, good to see you. The judge will have him in regular clothes, but will not allow him to be without restraints. He'll be restrained, yeah. I'm not. I think they're probably going to have to restrain him. I think they'll probably go with restraining him, maybe civilian clothes. We'll see. Let's get started. Defendant Tyler James Robinson, by and through undersigned counsel, hereby moves the court for an order permitting Mr. Robinson to appear at all proceedings in civilian clothing and without physical restraints. As articulated herein, this motion is grounded in Mr. Robinson's rights to a fair trial due to due process of law, the presumption of innocence, and to a reliable penalty determination under state and federal constitutional provisions, including the 4th, 5th, 6th, 8th, and 14th Amendments of the United States Constitution. Requested relief to determine motion. Prior to the motion, the court should order the following. An order compelling the Utah County Sheriff Department to disclose any and all files, records, and correspondence and reports created by or in the possession of the department relating to the defendant's motion. A temporary order allowing Mr. Robinson to appear in clothing, civilian clothing, without visible restraints at any in-person public hearing held prior to the determination of this motion. Number 3, a closed hearing for the court to receive evidence regarding the need for physical restraints in this particular case and the opportunity to further brief this issue. Memorandum. Mr. Robinson makes 2 requests. Number 1, to allow him to appear at all proceedings in civilian attire. And number 2, to be without physical constraints during all in-person hearings, both pretrial and trial. There you go. Someone asked that question just a second ago. So both pretrial and trial. These requests are necessary to maintain the presumption of innocence, to protect Mr. Robinson's right to a fair and impartial trial, and to maintain courtroom decorum and dignity. Recognizing that the court must make an individualized assessment of a purported need for physical restraints, Mr. Robinson asked the court for an order directing the Utah County Sheriff's Department to disclose relevant records and for the opportunity to supplement his motion after an evidentiary hearing on the issue of physical restraints. To avoid the very prejudice, this motion seeks to prevent Mr. Robinson request a temporary order from the court allowing Mr. Robinson to appear at any pretrial proceedings in civilian clothing and without visible restraint while this motion is pending, and a further order granting a closed hearing at which the court can take evidence regarding the need for physical restraints in this particular case. A closed hearing. Um, Widow, you didn't unalive a high profile man in broad daylight? Yeah. Yeah, he will be in chains from now on unless he's somehow not guilty. Valerie says it's sad. Okay. Number one, the law of courtroom restraints. The presumption of innocence lies at the heart of our system of criminal justice. In a series of cases, the Supreme Court has held that constitutional principles of due process and non constitutional principles of fair administration of justice require courts not to impose excessive physical restraints on the accused who is still presumed innocent. In Illinois versus Allen, the Supreme Court that an accused could be tried while shackled and gagged, or even removed from the courtroom altogether, but only as last resorts based on the accused's repeated and aggravated refusals to behave in court. Defendant Allen earned such rare treatment in his jury trial by repeatedly disrupting the proceedings to an extent that an orderly trial was impossible if he was present and able to speak and interrupt. In Holbrook versus Flynn, the court found acceptable the presence of uniformed police in the front row of the courtroom, finding that the security measure was not inherently prejudicial practice like shackling, that quote unquote should be permitted only where justified by an essential state interest and specific to each trial. I don't think, I mean, I get it. He's dangerous, yes, but I feel like maybe give him a chance to not go in shackled or restrained. I mean, is he gonna be Taylor Schabusiness? Hossein, can you please tell us about your girlfriend? But yeah, it's an inside joke. Um, so, unless he acts like Taylor Schabusiness, I feel like isn't necessary. Drawing on English sources older than the United States, Deck identified the traditional common rule that the defendants must be brought to the bar without irons or any manner of shackles or bonds unless there may be evident danger of an escape. Only in extreme and exceptional cases where the safe custody of the prisoner and the peace of the tribunal imperatively demand the manacles may be retained. They're comparing it to the case of Deck. In Deck, the Supreme Court explained that judicial hostility to shackling effectuates three fundamental legal principles: preserving the presumption of innocence to which every criminal defendant is entitled, ensuring that a defendant is able to participate meaningfully in his or her defense, and maintaining the dignity of the judicial process. While neither the Supreme Court nor an Ulta, I'm thinking the makeup store, Utah Appellate Court have yet addressed the issue in post-Deck case, it has been held that the right to be free from unwarranted courtroom restraints applies whether the proceedings is pretrial, trial, or sentencing, with a jury or without. United States versus Sanchez Gomez, vacated on other grounds. The right, quote unquote, respects of our foundational principle that defendants are innocent until proven guilty and is implicated by the perception of any person who may walk into a public courtroom as well as those of the jury, the judge, and the court personnel. A presumptively innocent defendant has a right to be treated with respect and dignity in a public courtroom, not like a bear on a chain. Hi, Mike. Numerous courts agree. United States versus Williams. After carefully reviewing this case law, this court would be remiss if it didn't state its firm conviction that a broader qualified right of a criminal defendant be unshackled exists and should be recognized at non-jury proceedings. The due process right to appear without unjustified restraints applies to every court appearance, including non-jury pretrial hearings. The routine and unexplained use of visible Restraints does violence to each of the three fundamental legal principles recognized in DEC, essential pillars of a fair and civilized criminal justice system that are no less implicated when the fact finder is a trial judge rather than a jury. These cases and many others demonstrate, oh, let me turn the page. Demonstrate two critical points. First, decisions about extraordinary restraints are decisions for the judge and cannot be delegated to security or correctional personnel. Second, the reasons for the limits on such extraordinary restraints apply to criminal hearings. Broadly, those reasons are not limited to only what a jury might see. No delegation of the judicial responsibility. One central theme of the law of the courtroom restraints is that the trial judge is the person responsible for making the decisions. The judge cannot simply delegate that responsibility to the sheriff's department or any other correctional or security staff. The Utah Supreme Court has made this point by holding in Chess versus Smith that a trial judge has a responsibility to inquire as to why a defendant is appearing in court in prison clothes, even in the absence of defense objection. Absent such an inquiry and reasoned determination that such appearance is necessary, automatic reversal is a consequence. The trial court should look at the particular facts of the case and the conduct of the proceedings and should balance the need for safety and security in the courtroom against the potential for prejudice. The federal courts have more explicitly held that a trial court cannot delegate decision making on the issue of physical restraints or courtroom attire to a third party. In Lopez versus Thurmer, although a trial court's decision about the required level of security during a trial are entitled to deference, those decisions must be made by the court itself. The trial judge may not delegate his discretion to another party. Trial judge in United States versus Miller, the trial judge abused discretion by deferring without explanation to Marshall's recommendation that the defendant wear stun belt in jury trial. The use of physical restraints is subject to closed judicial, not law enforcement scrutiny. This need for a decision by the judge runs through the Supreme Court's decisions on courtroom restraints as well as Allen. C. Allen, this judge. Okay, I'm going to skip that part. B. It's not just about the jury. The use of courtroom. Oh, let me turn. This make First Liberty says this may come down to Utah specific rules, but I doubt they take leg irons off. They may take him off handcuffs in the courtroom. That's it. Dreaming says what we know of this motivation was that it was deeply personal. I'm not convinced yet he's a threat. Yeah, I agree. I agree. Okay, it says it's not just about the jury. The use of courtroom restraints has been litigated most often when the restraints are used during jury trials. That's where the dangers of unfair prejudice are more severe, and where, if any restraints are to be used, the usual course is to ensure they are never visible to the jury. Yet, the reasons for the limits on courtroom restraints apply more broadly. They weigh in favor of applying those limits to pretrial proceedings. The court laid out these reasons in Deck versus Missouri. First, the criminal justice system presumes a defendant is innocent until proved guilty. Visible shackling undermines the presumption of innocence and the related fairness of the fact finding process. Judges are trusted to be less vulnerable than lay jurors to this and other forms of unfair prejudice. However, the psychological reality is that human beings who serve on the bench are likewise not immune to such subconscious and subliminal influence from seeing a human being in chains to protect others from him. It cannot merely be assumed that judges are immune from the prejudice and bias caused by visible shackles. We judges are human, and the sight of a defendant in restraints may unconsciously influence even a judicial fact finder. I do agree with that. I do really think that um, that could be a factor in someone's judgment or decision. Second, DECA invoked the right to counsel because full shackles can interfere with the accused abilities to communicate with his lawyer. Courts have long expressed concern that shackles can be heavy and painful, distracting the accused from focusing on his defense. Sorry, let me make sure I'm on that. Okay. Um, and in Durham, restraints may confuse the defendant, impair his ability to confer with counsel, significantly affect the trial strategy he chooses to follow. These forms of interference do not depend on whether a jury is present or even on whether the shackles are visible. Third, and most important here, judges must seek to maintain a judicial process that is a dignified process. The Deck Court continues, the courtroom's formal dignity, which includes the respectful treatment of defendants, reflects the importance of the matter at issue, guilt or innocence, and the gravity with which Americans consider any deprivation of an individual's liberty through criminal punishment. And it reflects a seriousness of purpose that helps to explain the judicial system's power to inspire the confidence and to affect the behavior of the general public whose demands for justice our court seeks to serve. The dignity is for the good of the institution and the public. In Allen, the Supreme Court acknowledged that the use of shackles and gags in court is itself something of an affront to the very dignity and decorum of judicial proceedings that the judge is seeking to uphold. Indeed, a presumptively innocent defendant has the right to be treated with respect and dignity in the public courtroom, not like a bear on a chain. We must not exaggerate the distance between us, the lawful ones, the respectable ones, and the prison and jail population, for such exaggeration will make it too easy for us to deny that population the rudiments of humane consideration. Such routine treatment is unfair to the defendant and it diminishes the courts. Courtrooms are palaces of justice imbued with a majesty that reflects the gravity of proceedings designed to deprive a person of liberty or even life. A member of the public who wanders into a criminal courtroom must immediately perceive that it is a place where justice is administered with due regard to individuals whom the law presumes to be innocent. That perception cannot prevail if defendants are marched in like convicts on a chain gang. Both the defendant and the public have the right to a dignified, inspiring, and open court process. Thus, innocent defendants may not be shackled at any point in the courtroom unless there is an individualized showing of need. The Utah Supreme Court made essentially the same point in condemning trials at the accused in prison garb. It would seem that the occurrence of a defendant armed with the presumption of innocence standing trial before a jury in prison clothes should long ago have seized a decent respect for a basic fairness and indignity of appearing in the court of law in clothes which mark a defendant who has not been convicted as a lawbreaker would suggest just as much. The factors to be considered and the need for a hearing. Because of the inherently prejudicial impact of appearing shackled before the jury, courtroom shackling is permitted only as last resort. Shackling should be permitted only where justified by an essential state interest specific to each trial. Reviewing courts require a showing of necessity before tolerating the trial's decision to shackle. Shackling is an extreme measure that the Supreme Court considers a last resort. Any court considering such an extreme measure must first establish that it is actually necessary, not simply a matter of practice or convenience. And in such making such a determination, a district judge must scrupulously make a case-specific and individualized assessment that supports his decision to shackle a defendant and provides a reviewing court with an adequate record. Thus, a trial judge may impose restraints only when confronted with disruptive, contumacious, stubbornly defiant defendants, and shackling must be limited to cases urgently demanding that action. Furthermore, before a court may shackle a disruptive defendant, it must first pursue less restrictive alternatives. Lesser restraints may include increasing courtroom security personnel, warning the defendant of the consequences of disruptive behavior, such as the possibility of contempt or removal. Under decided case law, a defendant is also entitled to an adequate opportunity to challenge untested information that serves as the basis for courtroom restraints and to address all other factors relevant to a decision to impose restraints. Luigi Mangione, he was shackled, right? If I remember correctly. Vanjie says, yeah, I think he shouldn't be shackled. If they're worried about safety, maybe have more security available. Yeah. First Liberties, I kind of agree with that. First Liberty says adding more bailiffs is a similar concern. Too many security precautions can bias a jury or general public against him. It's easier to keep him in cuffs. The law prohibiting court appearances in jail or prison clothing. Although the right to appear free from unjustified restraints arises most often in shackling cases, federal and state courts recognize that other courtroom practices implicate due process as well. For example, the Supreme Court has held that, quote unquote, compelling a defendant to wear jail clothing violates due process because it furthers no essential state policy and creates an unacceptable risk of impersonal factors coming into play. Compelling an accused person to wear identifiable prison clothing at a jury trial, absent exceptional circumstances, has been held to be inherently prejudicial. Defendants who are compelled to appear before the jury in handcuffs, shackles, or prison attire suffer prejudice without unconstitutionally undermines the presumption of innocence. As with forbidding unnecessary shackling, the rationale of forbidding the defendant's court appearance in civilian clothing extends beyond its effect on potential jurors. As the Colorado Supreme Court found in the very first case in the country prohibiting trial in jail or prison clothing, the mind of a prisoner would be as much disturbed as his mental faculties, as much confused and embarrassed by carrying on his person such brand of incarceration as requiring a prison to wear the word county jail branded upon his clothing. Yeah, I think the clothes is fine. What do you guys think? I think you should be allowed to wear the clothes. Maybe wear handcuffs under the long sleeved button up. Ew, yeah, Wade, yucky. First Liberty says Luigi Mangione was shackled, but this is something that can vary by state. To my knowledge, all states restrain defendants when there's a death involved. I mean, he does he's innocent until proven guilty, right? Having everyone in the courtroom wear prison that's funny. Hussein says have everyone in the courtroom wear prison clothes. Similarly, the Utah Court of Appeals has held in order to protect the presumption of innocence, a basic component of a fair trial. Criminal defendants are entitled to the indicia of innocence. Indicia of innocence includes the right of a criminal defendant to be tried wearing civilian clothing rather than the identifiable as prison or jail attire. And unlike other indicia of guilt, physical restraints, the Supreme Court and the Utah Court of Appeals have recognized that compelling an accused to wear jail clothing furthers no essential state policy. The wearing of prison garb certainly could have little or nothing to do with security precautions in this case. It was said in the Hernandez versus Beto case. The application of the law to this case. Mr. Robinson should be permitted to don the indicia of innocence. In the modern age of ubiquitous internet access and unrelenting media attention to high profile criminal cases, the prejudicial effect of a criminal defendant appearing in shackles, jail attire, and bulletproof or the S word. And by S word, I mean SUICIDE vest at any the turtle vest at any hearing threatens fundamental fairness. These appearances increase the likelihood that the future jury pool will be exposed to Mr. Robinson in this state. In this case, where publication of each and every pretrial hearing is a foregone conclusion and where Mr. Robinson faces the potential penalty of death, additional care must be taken to ensure Mr. Robinson receives a fair trial by impartial jury. See Sampson versus United States. The right to an impartial jury is nowhere as precious as when a defendant is on trial for his life. True, true. Wasn't Sarah Boone even shackled? She needs to be, right? First, are they trying to get this guy to have to wear shackles and prison clothes? I guess we'll have to wait and see. Yeah. Indeed, let's continue. Indeed, the Supreme Court has stressed the acute need for reliable decision making when the death penalty is at issue. Reliable decision making must be grounded in admissible evidence, not on innuendo derived from defendant's custodial status. Illustrative of the magnitude of the issue, on September 16th, 2025, at 3 p.m., Mr. Robinson appeared for the first time in this case from the Utah County Jail via WebEx. The hearing was streamed live and covered by media outlets the world, including BBC, Al Jazeera, ABC, CBS, NBC, Newsweek, NPR, Daily Mail, Fox, CNN, and countless others, generating approximately 18,000 new search results. Mr. Robinson's physical appearance alone was and is subject to endless scrutiny and speculation. One article described Mr. Robinson during his initial appearance as emotionless and staring blankly ahead and sporting slightly mussed locks, several days worth of facial hair, and wearing a green turtle suit smock. With each development in this case generating thousands of articles and comments online, the likelihood of potential jurors seeing and drawing conclusions regarding Mr. Robinson's guilt and or deserved punishment from obvious signs of pretrial incarceration will only increase. Okay, so they're saying that he didn't look what professional at the first hearing. Is that what I'm getting? Is that what they're getting at? Sarah Boone was in leg irons until trial. Yeah, every state is different. Okay, let's continue. Indeed, given the pervasive media coverage in this case, the repeated and ubiquitous display of Mr. Robinson in jail garb, shackles, and a vest will undoubtedly be viewed by prospective jurors and will inevitably lead to a prospective juror perception that he is guilty and deserving of death. The Cloak of Innocence. Empirical study finding that a defendant dressed in prison jumpsuit versus a dress suit was seen as more aggressive, and that this perceived aggressiveness resulted in defendants being found 5.27 times more likely than mock jurors in the formal attire condition to render a guilty verdict than a not guilty verdict. I like when they include the numbers. You know what I mean? Nancy I'm skipping that name. The effect of pretrial publicity on juror verdicts was examined through a meta analysis of 44 empirical tests representing 5,755 subjects, finding that subjects exposed to negative PTP, pretrial publicity, I think is what that means, were significantly more likely to judge the defendant guilty compared to subjects exposed to less or no negative pretrial publicity. In fact, of world war I'm sorry. In the face of worldwide scrutiny, permitting Mr. Robinson to wear civilian clothing for court appearances is a minor inconvenience compared to the already present concerns with securing a fair trial before an impartial jury. B, the court must make an individualized assessment to justify any restraints, and in this case, the shackling of Mr. Robinson is not justified. The court should allow Mr. Robinson to appear at all proceedings without restraint, given the need for particularized evaluation of the circumstances of this case. The court should order appropriate disclosures by the relevant governmental entities, i.e., the Utah County Sheriff Department, and thereafter take evidence on this issue. Mr. Robinson requests the opportunity to supplement briefing after the evidentiary hearing. The rule that a defendant be tried in the garb of innocence has generally been extended to include a defendant's right to be tried without being shackled, chained, bound, handcuffed, gagged, or otherwise physically restrained. The use of restraints is itself something of an affront to the very dignity and decorum of judicial proceedings that the court seeks to uphold. In addition, even when not visible, restraints impact the ability of the criminal defendant to participate in the proceedings by causing confusion or distraction, impairing communication between the defendant and his counsel, and creating discomfort or pain. As stressed in Allen, one of the defendant's primary advantages of being present at the trial is his ability to communicate with his counsel is greatly reduced when the defendant is in condition of total restraint. The lower federal courts have observed two further weaknesses in imposing physical restraints. They may confuse and embarrass the defendant, thereby impairing his mental faculties, and they may cause him pain. As discussed above, the Supreme Court has found that the Fifth and 14th Amendments prohibit the use of physical restraints visible to the jury absent at a trial court determination in the exercise of its discretion that they are justified by a state interest specific to a particular trial. Thus, trial courts should carefully consider the need for restraints to prevent an escape, resort to violence, or disruption of the trial. Restraints, because they are regarded to an extreme measure, should be employed only in the presence of a special need. A defendant appearing in unjustified visible restraints is due process violation so serious that on appeal, the state must show that a defendant was not prejudiced beyond a reasonable doubt. His poor hands are in pain. If only he hasn't put himself in that position. I agree. Those things are really painful, though. 𝐼𝐸𝐽 official channel. Hey, good to see you. Thank you for being here. Okay, Mr. Robinson is a 22-year-old facing long resident. I'm sorry. Can I read? Mr. Robinson is a 22-year-old lifelong resident of the United State of Utah. He has no criminal history and, upon information and belief, has been polite, deferential to jail staff, and without any disciplinary issue while in the Utah County Jail. So he has been polite, no write-ups, no issues while he has been incarcerated. Although he has been accused of, but not convicted of, aggravated murder, the fact alone is insufficient to justify restraints. The mere fact that a jury convicted a defendant of first-degree murder is not a sufficient basis for a decision to shackle him during the penalty phase. Mr. Robinson intends to exercise his right to be present at all stages of these criminal proceedings as constitutionally guaranteed. The court should allow him to exercise this right without looking like a bear on a chain. As noted above, the world is watching Mr. Robinson in these proceedings. Yes, yes, we are. Even in pretrial proceedings, additional care must be taken to preserve the presumption of innocence and to prevent tainting the pool of jurors that will ultimately decide Mr. Robinson's guilt or innocence. And if guilty, if Mr. Robinson should receive the death penalty. As such, the court should order the appropriate disclosures by the Utah County Sheriff Department and thereafter set a hearing for the production of evidence necessary for the court's determination. Finally, given that the court and jail security protocols and prejudicial material and opinions not admissible at the guilt phase of this trial will be evidenced at the hearing, it is reasonable and appropriate for this court to disclose those proceedings and maintain the transcript, evidence, and pleadings commenting thereupon as private in the record. If disclosure of the alleged prejudicial material is essential to the conduct of the hearing on the motion for closure, the court should first seek a voluntary agreement from the parties who wish to be present that they will not disclose the allegedly prejudicial information that is disclosed at the trial or the trial has concluded. Absent such an agreement, the court may close the courtroom in order to conduct in camera to conduct in camera whatever proceedings cannot be conducted without disclosure of the alleged prejudicial information. Conclusion. Based on upon the foregoing, the court should order relief consistent with Mr. Robinson's request. There it is. There it is. Oh, Exhibit A. Before the court's defendant's motion to wear street clothing to all public hearings, having considered the motion for good cause, showing the court will temporarily grant the motion. Oh, I thought I was done. My bad. Oh, there we go. If you guys want to see this. You guys are like, so what was the response? So it says, having considered the motion for good cause, the court would temporarily grant the motion for purposes of the hearing noticed for September 26, 2024. Oh, this is the first one. Wait, what? Oh, just kidding. Forget that. Forget you guys saw that document. Forget it. Forget it. You just got a notification. Oh, for the Kenzie text. Forget it. I was jumping into Brian Koberger. You guys are like, what? No, that's it. So we gotta wait to see, I guess, what they're gonna decide. Not me jumping into Brian Koberger. I do have a Brian Koberger live coming up. Just a bear on a chain. I know. Court documents are endless. I love them. I love the court documents. Anyways, that's a quick live. I just wanted to get through that document and reading it because I was gonna just read it by myself, but then I'm like, why do that when I can do that with you guys? Definitely make sure you give it a like, please. Turn on your notifications. We're hopping over to another live right now. We are doing an early reading of the Kenzie text. It's going to be a rather short one because I have an appointment, so we might have to break it up over there. But anyways, thank you for being here, guys. I will see you on the next one. That was the new document for Tyler Robinson, the alleged KILLER of Charlie Kirk. Thank you for being here, and I'll see you on the next one.